Okay. Good afternoon all. Let's start with the next set of fundamental rights. Of course, most of it is easy, you would have already studied them. Freedom of speech and expression, obviously very broader one, broader interpretation. What all does it include? Just try to recall once. It includes your freedom of press, it includes right to information, so many of those things. You can keep on adding under that. It's a very broad term. Fine, right to silence, most important ones. Even that kind of questions also UPSC has not asked, but just to mention. So many cases are there that we need not discuss. Freedom of press, or freedom of silence, right to silence, right to information, RTI. Freedom to express also includes what? Freedom not to express. So all of those things is part of your which one? Freedom of speech and expression itself. It's a very broader one. Reasonable restrictions, totally how many? 8 grounds are there. Sovereignty and integrity of India. Security of India. Friendly relations with other countries, with other states. Friendly relations with other countries. Public order, morality, defamation, contempt of court, incitement to an offense. Other than this, you don't have to read anything new. Totally 8 grounds. Sovereignty, integrity of India, security of India, friendly relations with other countries, public order, morality, defamation, contempt of court, incitement to an offense. Totally how many? 8 reasonable restrictions for freedom of speech and expression. Fine. In detail, obviously, when we discuss, we will discuss about sedition here itself and so many other things, but all those are not necessary here. Just to mention what is not there, right to strike is not a fundamental right, right to band or right to strike, but right to protest, right to strike or burn, not a fundamental right. And obviously 19, entire 19 is what? Article 19, entire 19, only for whom? Citizens. When I think you would have copied it, entire 19 only for citizens. In other words, not for foreigners. Fine? Okay. So then just extension of that. 19, as I told, right to strike, right to band is not a fundamental right, but right to protest, right to dissent, right to picketing, so many other ones are already part of Article 19, freedom of speech and expression. 19 clause 1 subclause B, freedom of assembly. Just two keywords. What is what? Just extension of that. Right to assemble peacefully without arms in public place. Reasonable restrictions. Sovereignty, integrity of India. B, public order. So just said, there is no need to discuss anything else after this with respect to this article. Freedom of assembly, that is, one is peacefully, without arms, public place, reasonable restrictions, sovereignty, integrity of India. Second is public order. Quick. Fine. Then 19 clause 1 subclause C, freedom of association. Again, as he told, association means what? Anything, NGO, SHG, cooperative societies, so many things you can add. In short, companies, this, that, political parties, all of them. In short, that is your freedom of association. Fine, then to clarity, what is it? It does not include right to get the association registered, or recognized. Because if you want to get it registered, what do you need? You have to fulfill certain conditions. So, because if you say right to get the association registered is a fundamental right. So, what does that mean indirectly? Government cannot, reject your registration so easily. So, as of today, right to get registered is not a fundamental right. That means it depends on whom then? It depends on the act, it depends on the government. If you make it as a fundamental right, government cannot put restrictions on you. So, that is, you only have the freedom of association, means freedom to establish it, but not to get it registered or recognized. 1. 2. The second one, clarity. Again, all these Supreme Court clarities. What is it then? Also includes freedom not to get associated. Freedom not to get associated. In simple terms, what does that mean? Nobody can force you to join any particular association. And so that is includes freedom not to get associated. Then obviously extension, same. One is what? Sovereignty, integrity of India. B, public order. C, morality. Sovereignty, integrity of India, public order, morality. Fine, overall 3 grounds of reasonable restrictions. Fine. Yeah, then next one. 19 clause 1 subclause D, freedom of movement throughout territory of India. So territory of India means obviously which one? States, union territories plus acquired territories. Throughout the territory of India, freedom of movement. Again same reasonable restriction, very simple ones. Which one? First is interest of ST. 2. General public interest. Interest of ST and then general public interest. Fine. So 2 grounds of restriction, obviously as I told, so many cases are there for that, that doesn't matter. And remember, right to travel abroad doesn't fall here, right to travel abroad falls where? Article 21, because this only says what? Within the territory of India. Understood? Again, that we'll discuss. That's your Menaka Gandhi case. Subclause E, freedom of or freedom to, whatever, or directly divide it. 2. One is residence, second one is settlement. This is temporary, that is permanent. Fine. And then which one? Reasonable restrictions, same reasonable restrictions. Interest of ST, general public interest. Fine, that is your freedom to reside and freedom to settle. Then clause 1 subclause G, because F is what? Right to property, already abolished, we will discuss that later. Freedom of profession. Understood? Obviously for what purpose? Obviously it is for what purpose? To earn livelihood. Understood? Then, however, in other words, whatever directly right, state can prohibit anything. State can prohibit or nationalize or monopolize any activity. State can prohibit or nationalize or monopolize any activity. Fine. 2 is what? State can, what do you call as this, prescribe educational qualifications for any profession. In simple terms, medical doctors, if you want to practice medicine, you should have MBBS degree or whatever, the dental, all of them. Educate or lawyers for that matter, or architects for that matter, prescribe educational qualification for certain educational qualifications for certain professions. State can prescribe educational qualifications for certain professions. Fine. More or less rest all is same. Obviously, if we have prohibit immoral activity, if any activity, yeah, okay, fine. That and that you can include immoral, dangerous activities, all of those things. Cases are there. All of those things are not necessary here. In prelims, all of those doesn't matter. 20. Protection in case of what? Conviction for offences. So 3 components you have. First one, no ex post facto law. So what does that mean? In simple terms, no retrospective law in criminal aspects. No retrospective no retrospective application of criminal laws. That's it in simple terms. You cannot apply criminal laws retrospectively. From back end date, it's not allowed. Or in other words, you can only arrest an individual or punish an individual based on violation of a law which was in force when the crime was committed. Understood? Even the punishment has to be only whatever was there on the date when the crime was committed. In the future, if you increase the punishment, that you cannot apply back-end dates. Remember, famously we keep telling that the Nirbhaya case example. Understood? Because when the Nirbhaya gang rape happened, so for minors, what is it? Juvenile Justice Care Act, if you recall famously. Fine, in the I think 2015 or 2016 they amended Juvenile Justice Care Act, but that doesn't apply to the 2012 minor because no retrospective application of criminal laws. It's as simple as that. Fine, no ex post facto law. 2, no double jeopardy. In simple terms, what does that mean? Cannot be punished for the same crime more than once. Cannot be punished for same crime cannot be punished for the same crime more than once. No double jeopardy. 3, no self-incrimination. No self-incrimination. What does that mean? One cannot be forced to act as witness or evidence against themselves. To act as witness or evidence against themselves. One cannot be forced to act as witness or evidence against themselves. That is no self-incrimination. But obviously what they can do? Those, if we want, clarify that. However, for this, what they can collect? Fingerprints, signatures, blood samples, hair samples, fingerprints, signatures, blood samples can be forcibly collected. Can be collected. Obviously, even forcibly they can collect it. Fingerprints, signatures, blood samples can be collected even forcefully. Blood samples can be collected. Fine. That is your no self-incrimination. Obviously, as I told, if in case, because we don't know that have to be remembered, yes, Selvi case. Selvi versus State of Karnataka. What is it? Recall, what is the point? Narco analysis and polygraph test cannot be conducted without court's permission. 1 point. 2, who has to be informed? Accused should be informed. Means accused should be explained about the process. The third is what is it? Any confession in such test, what is it not? Any confessions in such tests. Any confessions in such test, not an evidence in the court. Any confessions in such test is not an evidence in the court. Any confessions in such tests is not an evidence in the court. Fine. That's your overall famously which one? Article 20. Then 21. The most famous one, which is what? Right to life and liberty. Multiple times UPSC has asked. Morning also we saw that. Right to life and right to life and personal liberty, right to life and liberty. Fine. So first point, What is it? For both. Remember 20 is also for both citizens plus foreigners, because if you look at the words, what is the words used? No person shall be deprived of right to life or personal liberty except according to procedure established by law. So the word is person, that's why it applies to whom? Both Indians as well as foreigners. And so that is first aspect. Second aspect, what is the concept of this? Procedure established by law. And sure, this is a theoretical concept. Keep it in mind. Actually, largely we have derived this concept from where? Japan, they tell, yes, correct, but Japan itself actually brought it from US, US itself brought it from UK. So overall, actually the concept originated in UK, but you can tell it as Japan because we borrowed from there. You can tell it as Japan itself, although originally concept originated in UK. Two, Supreme Court upheld it in which case? Very famously, so yeah, A.K. Gopalan versus State of Madras. Famously A.K. Gopalan case. If you recall, we keep discussing the details of what is that case, everything. All that is not necessary for prelims. That is for you to understand. If you have done that, then automatically it is. Then what is this? Narrow interpretation. Narrow interpretation. What is the only check? What is the check? Is there a law? Is there an act? Answered. First question. What is the next one? Did the authorities follow the act and procedure properly? Did the authorities follow? Did the authorities follow act, procedure, rules properly? Did the authorities follow act and procedure properly? Unsure. That is a question. That's why what they tell, under procedure established by law, what are you protected against? Protection only against arbitrary executive action. Means if the law is bad, you can't do. But who can't work arbitrarily? Executive action. Authorities cannot work arbitrarily. Protection only against. Arbitrary executive action. So you are only protected from arbitrary executive action. In other words, you are not protected from arbitrary legislative action under procedure established by law. Understood? Yeah, so E.K. Gopalan case, narrow interpretation. What is the check? Is there an act? Is there a procedure and rules? Did the authorities follow those act, rules, procedures properly or not? That's it. Only protection against arbitrary executive action. Fine? Yeah, extension of this topic becomes which one? UPSC has already asked questions on it. Due process of law. First point borrowed from where? USA. Second point, not in constitution. It's not there in the constitution. And so third, just make a case. Very famously, obviously, Menaka Gandhi case 1978. Understood? Then write an equation. Due process. Okay, if you want other one, broader interpretation. Broader interpretation. Then both, protection against both. Which one? Arbitrary executive plus arbitrary legislative action. Protection against arbitrary legislative, arbitrary executive action. Due process of law equals procedure established by law plus is the act or rules, whatever. What is it? Non-arbitrary. Yeah, fair, just, non-arbitrary, fair, just, reasonable, non-discriminatory. Instead, all those things they check. That's why what famously we tell. That's what you will see earlier. Look at that question. Due process of law famously is called as what? Fair application of law or just application of law. Non-arbitrary application of law. Any words you can use. But that is, remember as we keep telling, as we discuss about in liberty. So for liberty what you have? Simple definition you have. This is simple definition, fair application of law. But for liberty what you also have? Most appropriate definition. In the morning we discussed what is the most appropriate definition. To develop oneself fully, to what do you call this? To realize your potential, your ambitions, your dreams, aspirations, whatever. Same way, this is simplest definition of due process of law. But in depth, in essence, what is it? Principles of natural justice. 3 ones. Just try to recall famously. I keep telling it. What is it? First one, right to be heard or right to defend oneself. Right to be heard. 2, right to fair trial. Means you are considered as innocent until proven guilty. Right to fair trial. 3, what is the third one? Exactly. Nobody can be judge of his or her own case. Nobody can be judge of his or her own case. And sure, that's why what I tell. At the core, due process of law is nothing but what? Procedure established by, at the core, due process of law means principles of natural justice. Without natural justice, no law can exist at all. That's the core principle. Due process of law at the core, in essence, means principles of natural justice. We'll get to that question. Fine. Another one in Maneka Gandhi case. Okay, that I famously keep telling. Recall, you tell. Golden triangle. Again, which case? Maneka Gandhi case. Golden triangle. Fine. Again, another one. What is it? So, Article 21 includes what? Dignified life. Again, which case? Same. 21 includes anything and everything required to live a dignified life. Anything and everything required to live dignified life. Article 21, Maneka. So, Maneka Gandhi case 3. In fact, 4. Another one, what? Right to travel abroad. That's why it's one of the landmark case. Right to travel abroad. So, overall, what is it? First is Maneka Gandhi case, Supreme Court introduced due process of law. Second one, golden triangle. Third one, it includes anything and everything required to live dignified life. Fourth one, Article 21 also includes right to travel abroad. Fine. All of these is part of your Article 21. And then today give a simple explanation. What is it? If in case they ask which is the most broadly interpreted article of Constitution, which one? 21. Because UPSC already asked multiple questions in your paper, which one? GS mains, GS2 if you have heard. Most broadly interpreted article of Constitution. Remember, invisible amendments to Constitution. Most broadly interpreted article of Constitution. And so just try to recall what all does it include today. Multiple times, so many times I have already asked. First is the very famous right to privacy. Obviously you know the case. Which case? Puttaswamy case, KSP case. Now within right to privacy, what all does it include? Within right to privacy you have right to be forgotten, reproductive rights of women, and short, right to choice, right to marry. That itself is a separate case again. Which one? Adya case. So fine, so many are there. Right to food, right to dress, everything parts of your right to choice. Remember, but abortion is not. Abortion is what today? Our right to abortion is what kind of right? It's a statutory right under MTP, Medical Termination of Pregnancy Act, but it is not yet a fundamental right. So that kind of question they can't ask, but if in case they ask, just keep it in mind. And so then a very famous one, which one? Again one or other way which is in news. Kind of current affairs you can say. Right to die with dignity, which is referring to which concept of The concept of passive euthanasia in India. Understood? Very famously Aruna Shanbag case for people in vegetative state. For other is what? Common Cause Foundation case for people who are chronically ill. So Kerala is the first state to pass a separate act on passive euthanasia, and Karnataka is what? Second state. If you have heard in Karnataka itself, you have that female, what is it, her name? Channa Basamma. She will be the first chronically ill patient, so who may undergo passive euthanasia. Whatever, but as of today, Parliament has still not passed an act. They have drafted a bill, but that bill has not yet become an act. So, act is not there passed by the Parliament, but who has passed acts? Kerala first, Karnataka second. If in case you do know that, please mention that on passive euthanasia. And remember, not a single patient has been executed in India on passive euthanasia. The first female will be what? Channa Basamma of Davangere district. If in case her case is taken forward, we still don't know, because there is an act now. Karnataka may go ahead with it, may not, we don't know. Whatever, I don't know the legal status, you can go and search. Now whatever, the point is what? Kerala first state, Karnataka second state, and what? No Parliament Act yet. There is a bill, draft bill, but no Parliament Act yet. Fine. And then obviously so many are there, all the other ones obviously, which one? Right to clean environment, very famously, which cases? MC Mehta cases, right to drinking water, sanitation, this, that, you keep on adding. Last year also UP current affairs again, what is it? That both Article 20 and Article 14 and Article 21 includes right to be protected against the adverse effect of climate change. If you want, just mention that also. Ranjit Singh case. Normally even in classes I tell you that Ranjit Singh case, or they call it as Ranjit Sinha case also. What is it? Right to be protected against negative adverse effects of climate change. Right to be protected against the adverse effect of climate change. Yeah, part of which article? Both part of Article 14, Article 21. Why Article 14? Because obviously what will happen? Climate change, even if you look at any history you take, so any kind of this huge cyclones, floods, everything, or any for that matter, obviously who will lose the house or who will die? Who will die? Obviously, who are the most vulnerable? Obviously the poor sections, people living in the inundated areas, those are only more vulnerable for it. That's why they have included Article 14. So that vulnerable sections are also have to be protected. And of course in general, what is it? Dignified life. How can you live a dignified life when you are negatively affected by some cyclones or tsunamis or whatever you call it as? How will you live a dignified life? That's why part of both the articles. Fine, this is a kind of current affairs. Those are not very, very detailed one. That passive euthanasia is also a kind of current affairs. Right to be, okay, another one, just to mention it. Not very landmark again, but just to keep it. What is it? The new right they are talking about? Personality. Right to personality. Under that again there is something called as right to publicity. In simple terms, what do you mean by right to personality? Continuously it is in news. Anil Kapoor case was there, and then which one? Karan Johar case was there, and then probably Ajay, some other actor, I think Abhishek Bachchan case was there, Rajnikant case also there. In simple terms, yeah, maybe that is also there. So right to personality means in simple terms, what is it? Means exactly, especially these artists and everybody, celebrities so called speaking, have the right to what? Their name, their face, their dialogue, their voice, their mannerisms, whatever. You cannot just make use of it in any AI apps or anywhere just like that. Especially for commercial purpose, you can't make use. Because for simple idea is what? How will the celebrities make money first of all? Obviously, how will they make money? Just imagine through advertisements, through this, how many crores and crores of money may they make. Using AI now, nobody needs to make an ad. Directly you can make an ad using them. Then what about their right to livelihood? And so that's why the overall concept, and obviously the image one, their reputation is there, their way of working is there. Now you can directly make videos just like that. So they may not even endorse that product, but using an AI you can tell that they are endorsing the product. So many, of course, we are in an era of fake videos, deep fake videos, all those ones, so things will obviously go out of control. That's why this will take huge turn again in the future. Right to personality. Understood? Yeah, so Delhi High Court had told that, as I told just famous one, I think it's better you refer Anil Kapoor case. Because I think as far as I know, his was the major case in which they referred it for the first time. Now so many people have gone to the courts. Right to personality. Sir, of course it is part of Article 21 itself. It's nowhere explicitly mentioned. Now they are tracing it back to Copyrights Act, Trademarks Act, all those one. Within that they are dividing into two. One is right to publicity, another one is right to privacy. So both are there, but overall just link it to Article 21. That's it. Clear? And then few others are there, obviously, as I told, right to shelter. So many are there. I think it's all not necessary. You can easily understand that. Again, custodial. Remember, just few days. I think last month or somewhere. Remember, there was a custodial death and torture. I think again in Tamil Nadu. Correct, in Tamil Nadu itself. Right against custodial torture. If they ask again, which one? Article 21. Right against custodial torture and death. Yeah, exactly. DK bus. Ange vehat mabudidira illa. OGP notes gilna. So okay, fine. So that's your DK Basu guidelines, correct. So all those ones. Fine, okay. So that is your Article 21, very, very detailed. In fact, the most important. Within that, there are still so many, but that's related to what constitutionalization of gender aspects and so many. Yeah, right to gender identity is also this. Obviously, which one? Navtesh Singh Johar case, but again keep it in mind, right to gender identity is there, but right to, what is not there? Right to marry for transgender is still not there. Just again clarifying, right to marry is not a fundamental right for whom? Transgenders. Right to marry is a fundamental right for whom? Heterosexuals, not for homosexuals. Right to marry, not fundamental right for transgenders. Yeah, that is that's not related to fundamental right angle, not related to Article 21, but yes, that's related to transgenders, Nalsa case. Right to marry, not a fundamental right for transgenders, but it is a fundamental right for heterosexual, means in general, men and women kind of one, it's a fundamental right, not in case of that Special Marriage Act, so many things that applied, not necessarily all of them. Yeah, so then broadly that is the ones. Then 21A, I don't even have to tell, very simple, quickly sum up, right to education, right to health is also fundamental right, Article 20, I think all those one you can easily understand. Which amendment? 86th Constitutional Amendment 2002. Understood? And obviously only till which one? Or only 6 to 14 years. Primary education. Now for this, to implement this, which act you have? Right to Education Act 2008. Within what you have that 25% reservation for economically, socially poor children, all of those ones. RTA Act 2008. 21 capital A. Originally itself it was a fundamental right. Which case, if you recall that? Unni Krishnan case. Unni Krishnan case, it was already part of fundamental right, which obviously which article again? RTE part of 21, but they added it separately as an article. Article 21, yeah, capital A. Supreme Court had told it that it is part of Article 21 in Unni Krishnan case 1993. Article 21, capital A. Then comes your Article 22. This is what? Protection in case of arrest for offences. That's also kind of favorite for UPSC. Protection in case of arrest for offences. Arrest for offences. And that first one is what? Punitive detention. Means what are the protections that you get in case of punitive? In simple terms, punitive means what? Punitive, look at the word. Punishment means after you have committed crime. After crime is committed. Obviously, you try to recall and tell very simple ones. What are the protections that you get in case of punitive detention? Right to be informed about grounds of arrest. Second, Right to be produced before the magistrate within 24 hours, excluding journey time. Understood? If you want, just mention that, yeah, under that protection in or rights that you get in case of punitive detention. Right to be informed about grounds of arrest. B. Unless magistrate authorizes further detention. And then what is the next one? That itself we forgot. Right to consult legal practitioner, lawyer. Right to consult legal practitioner. Fine, and then few exceptions are there, that doesn't matter much. This is in case of punitive detention. Then comes what? Yeah, then the very famous one, preventive. As the name says, how are you arrested here? Yeah, before offense is committed. You are arrested before the crime is committed. Obviously, A. First protection is what? Maximum period is how many? Maximum period of preventive detention. Maximum period of preventive detention is 3 months. Understood? Can be extended. With permission of. Can be extended with the permission of whom? High Court. 2. Again same. Right to consult legal practitioner. Right to consult legal practitioner. Again same. Right to be informed about grounds of detention. Again, unless they tell, exceptional cases all different. Right to be informed about grounds of detention. Right to be informed about grounds of detention. Fine. So this is our in case of what? Preventive detention. Of course, few exceptions are there. Parliament can make exception. That's a broader point. Parliament can make exceptions. Means when can you be arrested? In which cases preventive detention can be more than 3 months. If you recall, remember again recently Sonam Wangchuk case. So National Security Act was in news. Under that act, what? Up to 1 year you can be put under preventive detention. And so National Security Act itself is a preventive detention act. The very famous one. If in case you look at it from current affairs angle, National Security Act 1980 is a preventive detention act. Fine. Okay. So then next, related to that. Parliament Parliament can pass preventive detention laws on security of India, defense of India, external relations of India. Parliament can pass preventive detention laws on security of India, defense of India and external relations of India. Then next one is what? Both Parliament and state legislature can pass acts on security of state, maintenance of essential services, public order. Maintenance of essential services, public order. Parliament plus state legislature can make acts on security of state, maintenance of essential services, public order. As I told, very famous preventive detention acts are what? National Security Act, UAPA, the most very famous one, Unlawful Activities Prevention Act. They are all very famous ones. Fine. So this is the constitutional part, largely the constitutional part. Now comes here which one? There are so many obviously differences that you have to understand. One question they have already asked, but so many are still pending. Which one? Which normally also we discuss. Police custody, judicial custody. You tell what are the differences? What do you mean by police custody? As the name says, police. Accused is under control of police. Accused is under the control of police. And what is the intention? Obviously, to help further interrogation. To help further interrogation. Here judicial. Accused is under or accused is in prison, jail. Unsure. What is not allowed? Police. Police cannot consult, cannot meet accused. Again, obviously how? Without permission of magistrate. Police cannot consult the accused without the permission of magistrate. Police cannot consult accused without the consultation of magistrate, without the permission of magistrate. This one difference they have already asked it. Second difference, these are all they have not yet asked. Cognizable, non-cognizable. Fine? Yeah, cognizable means what then? Fine, make it as opposite. Obviously, you know, simple cognizable offences are what? The murders, rapes, terrorisms, sexual harassments, or child marriages, so many of them are cognizable. Non-cognizable or non-serious petty offences like defamation, trespassing of private property, so many are there. cheating case, forgery case. Just the opposite. Means what? Police can arrest only with warrant. Police can start investigation only with court's permission. Just opposite, that's it. You don't have to write, just write it as opposite. Yeah, that's your cognizable, non-cognizable. Right? That they have already asked. Then the concept of, this again is in use. Last year also NCRB criticized it just in the beginning of this year. Kind of you can say current affairs link. Under trial. According to NCRB, recent report of NCRB also, what is it? Greater than 70% of people in jails. More than 70% of people in jails are under trials. When you say under trial, what are they not yet? They are not yet convicted. Understood? Means their cases are still pending. Yeah, related to that concept is here written the concept of bail. Recall Supreme Court's famous statement in PUCL case. Recently also they repeated that in another case. I forgot the name, whatever case they repeated again recently, just 4 or 5 months back again. Same concept. What Supreme Court told? Bail is the norm. Jail is exception. In fact, what Supreme Court told? Right to get bail is also what? Article 21. Right to get bail, part of Article 21. Bail is a norm, jail is an exception. Right to get bail, part of Article 21. Right to get bail is part of Article 21. Of course, there are so many types of bails, keep it in mind. Broadly what they call as bailable offence, non-bailable offence. But remember, when you say non-bailable offence, don't take the exact English meaning. What do you mean by non-bailable offence? Difficult to get bail. Non-bailable offence in simple terms means what? Very difficult to get bail. Doesn't mean you cannot get bail. There is no offence for which bail is not available. For every offence bail is there. For some very easy, for some very difficult. So when you say non-bailable, difficult to get bail, keep that in mind. Don't take it as cannot get bail. Fine. And obviously there are so many types of bails. If you recall which one? Regular bail, anticipatory bail, fine, and regular bail you can divide into two. If your regular bail application is still pending but you want to get some relief, then what they'll give you? Interim bail. Then if your regular bail application is still pending, understood, but your charge sheet is, police is unable to file your charge sheet, then what police will give you? Courts will give you default bail. Understood? So basic point, keep it in mind. Regular bail is a normal bail application. That's the actual bail is regular bail. That's why the word regular, normal, common. If your regular bail is still pending, courts are actually not ready to give you bail, but they feel what? They feel that okay, they have, remember what you can say, you have some health issue, this, that, whatever. They want to give you 1 month break, 15 days break, 20 days break. Okay, go get some health issues, this, that, whatever it is. In that case, what they'll give you? Interim. That's why look at the term. Interim means what? Temporary. That is temporary bail until your original bail application, regular bail application is pending. In some cases, what will happen? Let's say charge sheet, if you recall, that we'll discuss then. What is it? Within 60 to 90 days, your charge sheet has to be filed. Some cases what will happen, police will not get the detailed investigation report. Some witnesses, evidences, all those things they are not getting. Or even if they submit, court will not accept your charge sheet. In that case, what courts will do? After 90 days, courts will mandatorily release you on bail. That kind of bail is called as what? Default. Why is it default? You are getting the bail now because of what? Because police failed to file the charge sheet which is accepted by the court. That is regular interim default. Now what is anticipate? Look at the word anticipate, means what? Exactly, you are asking for the bail even before you are arrested by the police. So because you are anticipating that someone else will go and put a case against you, that's why the police will come to arrest you. That's why you are anticipating your arrest and then taking the anticipatory bail. Clear? So that is for your which one? Those offences which, offences you might not have been committed, but for those in those cases where you have yet not been arrested, that's your anticipatory bail. Clear? Yeah, then comes your which one? FIR, zero FIR, charge sheet. You tell the differences. Yeah, please note down the differences. FIR, zero FIR and charge sheet. First point, FIR is what? Obviously filed by police. So police will draft it. So complaint is by whom? Obviously complaint by accused or affected members. Sorry, no, complaint by victim or affected members. Complaint by the victim or affected members. Complaint by victim or affected members. And so that's your FIR. In rare cases, eyewitnesses can also do it. If you want, you write that also, FIR. Rare cases, rarely, eyewitnesses can also file it. Rarely, eyewitness can also file it. Fine, that is your FIR. And then what do you mean by zero FIR then? What is the concept of zero FIR? Filed in any police station. That's the concept. In other words, not necessarily where? Not necessarily where the crime happened. Filed in any police station. Then why is it called a zero then? Exactly. No serial number, no number associated. Obviously, last simple common sense. Then what do they do? Though such what did the police do? Transfer it to respective station. Unsure. Was it mentioned in CRPC? No. Zero FIR. Not in CRPC. But what is it? But in which one? In BNSS, Bharatiya Nagarik Suraksha Samhita, it is there. CRPC, it was not there. And famously, which committee? Justice J.S. Verma committee. Whenever you say zero FIR, please keep it in mind. The committee is former Chief Justice of India, Justice J.S. Verma committee. Understood? So post Nirbhaya, that committee was appointed. He recommended it. Justice J.S. Verma committee. It's not there in CRPC, but it is there. It is mentioned in which one? BNSS. Bharatiya Nagarik Suraksha Sanhita. That's the concept of which one? Zero FIR. Zero because no serial number is associated. Yeah, then comes which concept? Then comes the concept of charge sheet. The name it says obviously what? Contains details of charges against accused. Contains the details of charges against accused. Details of the charges against accused. To be filed with courts within, to be filed with the courts within 60 to 90 days. To be filed with courts within 60 to 90 days. I'm sure that's what is the point. If charge sheet is not accepted, what do they do? You will be mandatorily, yeah, exactly. You will get the default bail. That's the idea. Of course, and then as I already told multiple times, what is the what Supreme Court had told? If an under trial has already completed more than 50% of the probable sentence, what do you have to do? They should get the mandatorily bail. There also judgments are there, but not able to implement it practically, but overall. And then what Supreme Court also said last year, again they repeated it, last year current affairs, what is it? Not a public document. Charge sheet is not a public document. This is also kind of current affairs, last year, not a public document. Means what? What does it mean in simple terms? Yeah, it is not available for common man, you cannot apply RTI. But FIR is what? FIR is opposite. FIR is a public document, charge sheet not a public document. FIR is public document, charge sheet is not public document. That's the concept of your charge sheet. Then comes your concept of what? Parole. Parole also they have already asked a question. Furlough. Furlough they have not yet asked. Parole, furlough. You recall the differences. Parole is given, parole and furlough both are given for whom? This is for. Bail is given for whom? Bail is given for accused. Parole and furlough is given for. Exactly. First point, write that under parole you write more or less same is under furlough. Given for convicts. Under parole, given for convicts. Or you can say temporary release of convicts, anything. Given for convicts to temporary release from prison. Given for the convicts to temporary release from prisons. Temporary release from prisons. Yeah, on an average how many is it? Normally around a month. Temporary release from prisons, normally around a month. Temporary release from prisons, normally around a month. Normally around a month. Then it is not a right. It is not a right. What do you mean it is not a right? That is can be rejected. Not a right. Can be rejected. Then given by prison authorities. So who will give? Prison authorities will only give. ASP prison, SP prison, Commissioner prison, so many will be there. Given by the prison authorities. Given by the prison authorities. Given by the prison authorities. Fine. Then next one. On specific grounds. Either health ground or some death in the family, some other event in the family, something. Given by the prison authorities on specific grounds. Then time period is not remitted. Means what? If you have gone out for 1 month, that 1 month is not subtracted from total sentence. Time period is not remitted. Time period is not remitted. Not remitted. Fine. That is the core difference, core points of parole. Furlough more or less same. First write the differences. Under furlough what you have to write first? Not a right. Sorry, it is a right. Under parole it is not a right. Here it is a right. What does it mean? Very difficult to be rejected. That means authorities cannot reject it so easily. It is a right. That is difficult to be rejected. Means prison authorities can't reject it. It is a right. Hence difficult to be rejected. Difficult to be rejected. Then normally given for life sentence, death sentence people. Lifers they call it as. Lifers means those serving life sentences. Normally given for life sentence, death sentence. Life sentence, death sentence convicts. Fine. Then time period remitted. Remitted means what? Subtracted. Time period is remitted. Yeah. Understood. And what is the intention of furlough? If you want that also mention. Intention is to allow the convict to mingle with the family and society. Intention is to allow. Intention is to allow convict to mingle, interact. Allow the convict to mingle with society and family. Allow the convict to mingle with the society and family. Sure, that is your parole and furlough larger differences. Rest all is same. Rest all is same as parole. Normally around 30 days. Who gives it? Prison authorities will only give it. What is it? Temporary release of a convict. Those are all same. Rest all is same. Just write that one point. Rest is same. That's your parole and furlough. Assured. And then they have asked you that one simple question. Just to keep it in mind. Remember on prisons they have asked. The first point. Prisons is which subject? Exactly. Prisons is a state subject. Because one question they have already asked. The reason was because in 2023 Ministry of Home Affairs released Model Prisons Act. So it's a state subject. But what is the Mother Act? Indian Prisons Act 1894 is the Mother Act. Mother Act means the Parent Act. Indian Prisons Act 1894. Obviously that means who had passed it? British had passed it. Like how if you recall Indian Police Act 1861 is the Mother Act for police. And so like that, because police is also which subject actually? State subject, but British during time, so that all the differences were not there. If you recall, until your 1919 Act and 1935 Act, this concept of state list, concurrent list, all those things were not there. And so that's the reason in 1894 everything central government will handle. Means at that time British time. Same way police, prisons also is same. And so Indian Police Act 1861, Indian Prisons Act 1894. But then gradually the power is given to whom? States. In other words, that's why what will happen? Every state will make their own rules with respect to what? Prisons. In other words, if you make it prison related means, sir, how many days will they give it to give you for parole? Here you have written what? 30 days. Is it same across the country? Obviously not same across the country. You tell reason. What is it? State subject. Every state will make their own rules. And so, sir, under which condition they will give it? Who will give it? May change. Whatever you have written is larger picture. If you take, this is the point. Maybe in Punjab and Haryana, actually they tell Punjab and Haryana it's a bit different. That's their wish because it's a state subject. Fine. On that only they have asked you question. Anything related to prisons as of today, who will make the rules? Exactly, state government will make the rules. But if you recall, MHA released a Model Prisons Act in 2013. Model Prisons Act in 2023. By whom? Obviously MHA. Why MHA? Because obviously it is dealing with what? Home affairs, crime. Now, just a legal angle. Now, why is it called as Model Prisons Act? First of all, how can Ministry of Home Affairs pass it? See, look at the convey. What is it? You are telling it's an act. Act means first of all, who has to pass it? Parliament has to pass it. If in case the Government of India level it is passing it. How are you telling Ministry of Home Affairs passing an act? That itself is not allowed. 1. 2. Prisons is which subject? State subject. How can Ministry of Home Affairs, Union Ministry of Home Affairs introduce it? 3. Why are you using the term model then? So, in other words, the core point is what? If it is a state subject, center, obviously we know Parliament what they cannot do. Cannot pass an act. 5 extraordinary circumstances are there. If you recall, national emergency, state emergency, 2 or more, that we'll discuss separately. That's interstate relations. In simple terms, Parliament cannot make an act on state subject. That's why what they release? They release model acts. What do you mean by model acts? Parliament is not passing it. Who will release it? Respective ministry will release it. Though the name is act, it's actually not an act. In other words, what you cannot do? You cannot implement. Model Prisons Act can't be implemented. So then what is it? It is a model act. Model means what? Like how they give you synopsis for your test series. It's like your synopsis. Using those synopsis, who should make their own acts? States, not should. States can make their own acts. Similar to Model Prisons Act, if you recall the past, there is Model Police Act. Again MHA. There is Model APMC Act. Again Ministry of Agriculture there. Why is it model again? Because agriculture is also its subject. State. Police is its subject. State. That's why Model Act. So got the core point. When you say Model Act, point number 1 is what? On a state subject, center is releasing some detailed rules. Though the name is Act, what is it not? It's actually not Act. It doesn't have any legal effect. Then what is it then? It's just a kind of a model act. That's why it is model. Model answer. Remember they keep telling model answers, model answer. It's like that, model answers. Using that, who can make their own acts? States can. What is it not? Not should, not must. If they want to make it, you don't want to, it's your wish. They cannot impose it on you. It's a state subject. Understood? Because 2023 they passed this. Past instance, my MHA introduced it. They asked that question, that prisons are regulated by whom, what is the model prison, what I think IPA 1894 also that asked. We'll go through that question. That's your another one related to prison. Yeah, 22 is a detailed one, that's more than enough. Yeah, fine. Yeah, then 20 or broader heading, which is what? All these are quickly till 28. We can just quickly just skim like that. Right against exploitation. Our goal is to at least complete fundamental rights today. Other things we can take care of it tomorrow, because rich everything will take some time. 23, 24. Right against exploitation. Fine? Yeah, simple one. You tell. What is 23? What is it? Prohibition of prohibition of human trafficking and forced labor. Assured again, against whom? Against state and private individuals. B. For whom? For both citizens plus foreigners. Then what Supreme Court has told? Absolute. In other words, what not there? Exactly. It is also absolute. In other words, no reasonable restrictions. Absolute, that is no reasonable restrictions. Rest all I think don't need to discuss even anything for that matter. If you want, same things. Human trafficking, forced labor, what is it? Same logic I have already told you multiple times. Mentioned, not defined. It also includes what? It also includes bonded labor, devadasi, includes bonded labor, devadasi, etc., slavery. Of course, state can force you for what? Compulsory military or social service. If you want, write that exception. Exception is compulsory military, social, compulsory military and social service is an exception. Compulsory military and social service is an exception. There is no need to remember anything other than this one for prelims aspect. 24, more simple, what is it? Prohibition of child labor. Less than 14 years. Now you have 2016 Act, Prohibition of Child and Adolescent Labor, Prohibition and Regulation Act. Now what they tell it as? Less than 14 years. Hazardous, non-hazardous. What is allowed, what is not allowed? Both not allowed. Assured, same, take it, then what? Adolescent, 14 to 18. You tell. Hazardous, not allowed. Non-hazardous, allowed. Of course, exception is there that less than 14 years can be allowed in which one? Entertainment industry, whatever reality shows, movies and all those things, including assisting the home kind of even whatever home related. Hazardous, non-hazardous, both not allowed. Adolescent 14 to 18, hazardous not allowed, non-hazardous allowed. This is an act obviously. But remember always, in general, what is the definition of child? Now, according to national child policy, everything, anybody less than 18 is child. This child is an exception, means what? Only in Article 24 context or 2016 Act context, children means what? Less than 14. In general, when you say children, what is it? Up to 18 or less than 18 is children according to national child policy. Even if you look at which one? POCSO, protection of children against sexual offences, also child means what? Anybody less than 18. Sure, because you never know, that kind of questions also they may ask. So in general definition, even according to UNESCO definition also, child means less than 18. That's why even if you take it Juvenile Justice Care Act also, juveniles refer to where they're less than 18. Up to 16 is different one, that is 16 to 18 if in case juveniles are involved in which one? Cognizable offences, heinous offences, then they tell the same IPC will apply or BNS will apply. That's an exception. In general, it is still 18. Assured always, anywhere. But that extent you never know. So they may ask it as a kind of, they may make it as a polity or current affairs, social justice, all of those they may link it. It doesn't like as we to recall that whatever morning you saw that Arunachal Pradesh kind of question. So in polity kind of question they have linked what? Environment, national park and everything. So what is the guarantee that polity, economy they might not link, polity, history they might, anything they can link. Geography, environment, agriculture is easy to link because overlapping subjects. So polity and economy are also equally easy to link because so much of overlap is there between polity and economy. Like how ancient, medieval, art and culture are easy to link because everything is interlinked. Same way modern India, post-independence India, in a way polity, easy to interlink. So that interlinkages is very, very important as I told you in the beginning. So always remember from now on whenever you study for prelims, please don't study in silos. Means what? As separate, okay, polity, I will only study polity for 1 week. Please don't study like that. Study obviously, when you read a subject, you read only individually. I am not talking about that. What I am talking, when you read a topic, when you keep on kind of revising or keep trying to memorize facts or something, what you do in your mind, you should link it with so many other things. See, for example, when you look at here, which one chronology of, okay, first Bombay state got divided, this, that got divided. So there itself what you have to link then, okay, you are talking about Arunachal Pradesh, you are talking about Mizoram, what happened at that time. So like how we study here, is there any, so try to link your environment also. Okay, you are talking about Madhya Pradesh, what are the major facts of Madhya Pradesh? Get those points. What about their geography, highest tribal population, which tribe is more there? Do you have any PVTGs, particularly vulnerable tribal groups there? How many national parks are there because MP has the highest ones? So whatever, remember that recent Ken, Betwa, where is it? All of those you have to link. Answered which rivers are there, geography angle also. Answered or if there is any, you do have legislative council there, you don't have there. Each and every perspective you have to see. Answered if you only look at it from one subject, so if in case they ask an interlinking of ones, it's a challenge then. Your mind, that's what, you look at your polity question, what will happen? I mean, prelims question. So 2-3 question might be polity. Next 3-4 question might be what? Economy. Next it can be geography. Next it can be, and whatever, everything gets mixed. So obviously your mind should also work like that. And so now it will be absolutely this year or in the future, what is that? Interlinking of the subject. Means within a question, what is it? Each and, I mean not each and every, you can say multiple subjects they'll interlink. So don't assume that okay, Article 21 means only they'll ask about fundamental rights. You never know, they may ask some other linkages also they may bring. Just telling you don't know. If they ask you directly, it's more simple, but you have to obviously prepare for the, what do you call this, kind of the difficult game, toughest game you have to prepare. Fine, fine, whatever, that is the point. So that's your Article 24, very easy. Then your what? Right to freedom of religion, 25-28. Again very easy ones. Multiple times, one or other way it will be in news. So the entire 25 to 28 is what? That simple logic also, if you apply, the answer will be there. Eliminate 15, 16, 19, 29, 30. Automatically others will apply. That's it. 25 again. Recall 4. What is it? Freedom of conscience, right to profess, right to practice, right to propagate. Easily you will understand, I don't have to tell. Conscience means what? You can have your own religious belief, you can tell it openly, you can practice it, you can spread it. Sure. And of course 25 also includes what? What does it include? Whatever, 2-3 days back obviously you celebrate Mahaparinirvan Divas. So right to Article 25 includes right to convert one's religion, means one religion to another. But of course, what is not allowed? Forcible conversion, not allowed. Fine? Yeah, then reasonable restrictions. Public order, morality, public order, morality, health. 3 reasonable restrictions. Public order, morality, health. Fine. And the very famous one, which is what? Just to keep it in mind, doctrine of I don't remember, though not exactly any issue was there in the recent times. The landmark Shirur Mutt case, 1954. In simple terms, what is it? Of course, they will not ask you the details here. If in case asked, what is divided? The name says essential practice associated with this freedom of religion. What does that mean? As the name says, Supreme Court, in other words, judiciary will determine which practice is an essential practice of the religion or not. Only if they say yes, it is an essential practice, you can continue. Sir, what is the definition? Of course, nowhere it is there. When you say doctrine of essential practice, what is it then? Shirur Mutt case means what? Not in constitution. It's not there in the constitution. In other words, who introduced it? Supreme Court has introduced it. It's a judicial innovation. It has got nothing to do with the constitution. So many cases are there related to that. That's not necessary. That's not related to your prelims. How will they decide whether an practice is an essential practice or not? Again, I have told you, they'll go refer holy text, they'll ask religious scholar, they'll see did the prophet or Jesus or whatever Buddha or Mahavira talk about it, how long has it been practiced, is it so essential that, essential means what the core theme, if you, Supreme Court, one of the case, Ratilal case, all of them they are told, what is it? It is such a practice that if in case you are not allowed to practice it, then what is it like? It's almost like you are not practicing the religion itself. Means what, in simple terms, you take away idol worship from Hinduism. What is it? Concept itself is gone. So because idol worship is what? It is a core of what you call this Hinduism. If you take that out, entire concept itself will be gone. So that is essential practice. Means it is the core practice of a religion which if it is not allowed to be practiced, it's almost like what? It amounts to non-practice of a religion or useless of practicing a religion. You take out namaz from Islam, concept itself is gone. So that's the what you call as core practices. So many cases are there. Obviously, I have already told you multiple times. Cases they don't ask it in polity, and obviously they can ask maximum one question on fundamental rights, maximum two. So they will not get to so much of depth in prelims. In fact, this itself is actually too much. They will not ask you like this in polity. I mean, in prelims I am telling. Mains, yeah, mains is a different game ball. Then 26 is what? 26 is broadly. Keep it in mind. 25 is broadly individual right. Me, you, everybody individually will get it. In other words, you tell. What is 26 then? Individual right means 26 is a group right. In simple terms, what is it? Right to establish and manage religious institutions. Establish. Right to establish and manage religious institutions. Right to establish and manage religious institutions. Short. What it also includes? Right to acquire property, right to manage such property is also part of it if you want, that also right. Right to acquire and manage property. That's what is your Keshavananda Bharati case. Right to acquire and manage property. Same reasonable restrictions. What are it? Public order, morality, health. Public order, morality, health. Health means obviously what simple aspect you take. For example, there are so many practices. There are few, but originally there were so many practices in which what will happen? Exactly, obviously. For example, you might have heard in so many festivals, even now it has almost drastically come down. Remember, they put a hook to the back of some people. I mean, what you can then have. Obviously, what will happen to the health? What will happen to the dignity? Like there's so many are there. In so many ones, women are forced to do so many other things. Those are all which will affect the health. That's why if health is being affected, what you can do? Such religious practice are not allowed. So, but it's a very detailed one. For example, if you have heard in Bora Muslim, Dawoodi Bora Muslims. So, under Muslims there is a group called as Dawoodi Bora. So, what is the controversy there? Genital mutilation they follow. For women, they conduct something called as genital mutilation. It's a very kind of a lot of people tell it. I mean, according to the medical opinion, that it's a kind of a harmful practice. All those ones are there. That's a different issue. It's a controversial. Let's not get into that. In the name of health, obviously, because health is affected, ideally it should not be allowed. But the case is still pending because a lot of people, under Article 26, they have still allowed for them to manage it. So like that, so many are there. Unsure. So those are all your religious practices in the name of health. I mean, in simple terms, if any religious practices is affecting anybody's health, what you can't do? You cannot practice it. If any religious practice is affecting public order, you cannot practice it. If any religious practice is going against a morality, like untouchability itself goes against, it's a basic humanity itself is goes against, not allowed. Like that, so many are there. Obviously, it's a very detailed one, but that is the point. Fine? Yeah, okay. Then comes 27, which is with respect to what? Taxes. In simple terms, nobody can be taxed for practicing or promoting any religion. Nobody can be taxed for practicing or promoting any religion. Short, simple examples are what? Jizya, pilgrimage tax abolished. Whatever Mughals used to do, whatever British used to do, you can't do that. That is one. Two is what? Public money cannot be used to promote one particular religion. Public money cannot be used to promote one particular religion. In other words, but you can use it for what? Promotion of all the religions. And so that is second. 3. Entry fee is not tax. Entry fee does not mean tax. Whatever the entry fees that collect in your most of the religious institutions, don't consider it as a tax, because obviously they don't have any such power to impose taxes. It is collected to provide basic facilities, is the point. Fine, that's your 27. Then 28. Even remember from yesterday, day before, also in Karnataka, new kind of a controversy is going on, that kind of a one, that Bhagavad Gita should be included in the books. Those are all your article 28. In simple terms, what is it? Freedom from attending what? Religious instructions in educational institution. Freedom from attending religious instructions in educational institutions. First is what? In simple terms, again, actually not a single question as we'll go through it. They don't ask you any single question on all these things. Government schools and colleges, not allowed. B. Missionary schools, madrasas, obviously name itself says. Madrasas, Vedic schools, all of those things. Obviously, what is it? Allowed. Third is what? Broadly, private schools and colleges. Allowed voluntarily. Private schools and colleges allowed voluntarily. If they want to, let them do it. If they don't want to, that's their wish. You can't force whom? You can't force children, especially if it is minor children. Simple logic, what you have to do? Get the permission of their parents or guardians or wards or whatever you call it as. All these will not matter much, just broadly keep it in mind. The example recently, whatever the controversy, continuously it's there for a long time, that should we include Bhagavad Gita, should we include all of those things. So because obviously it's not so easy, because it's part of what? In school, what you call in curriculum is what? Textbooks. Textbooks who makes? Government makes. Obviously government cannot include it so easily, because it promotes what then? It's like what? First category. Not only government schools and colleges, syllabus is made by whom? Government. So can government include anything related to particular religion in a textbook? Not so easy. Understood? But what is the difficulty, as we keep telling? The difficulty is, how will you differentiate between religion and morality? Because whatever in Bhagavad Gita also, obviously what you have? We have so many good lessons or whatever related to what? Ethics and morality. But the point is what? Same thing will be there in Christianity also, same thing will be there in Islam also, same thing will be there in others also. But of course now nobody accepts it, that they will only accept that only in Bhagavad Gita you have good things. That's a different issue. But the point is, how will you include that? It's a legal question. So that's why normally not so easy. But of course that will keep on going on. This typical politics, everybody knows that. So whatever, that's a different issue. Let's not get into that. That's your article 28. Then 29, 30. In simple terms, rights of minorities. A kind of current affairs is also there, because if you recall, two cases actually, which one? AMU, Aligarh Muslim University case was pending for a long time. Again recently Supreme Court told that what? Let it be a minority institution. That's right, article 30, but broadly. Fine? Okay, so first under that, article 29. From Prelims perspective only, broadly what do you call it as? Cultural rights. Understood? A, 29 is only for whom? First point, only for citizens. Second point, both minority and majority. It is given for both minority and majority. For both minority plus majority. Fine? Okay, any cultural conservation, that's it. Okay, I don't even have to write that, that's already there. Then if you take the term minority, rest all is not necessary, that's all mains part, that's not necessary here to go in detail. First point for minority, what is it? Same. Mentioned, not defined. 2. No definition, okay, fine, no criteria also. According to Government of India, okay, before that, sorry, under minorities. 2, what is it? Religious, linguistic. Assured, but again, on what criteria we don't have it. At present, what is it? According to Government of India, of course, Muslims, Christians, Buddhist, Jain, Sikhs, Parsi. Obviously, what minorities? Religious minorities. Muslims, Christians, Buddhist, Jain, Sikh, Parsi. Religious minorities. Sir, what about linguistic minorities? Every state will determine on their own. Understood? If simple terms in Karnataka, what? Tulu, Konkani, Telugu, Malayalam, Urdu, whatever. So in Tamil, all of them are called as what? Linguistic minorities. But every state will have their own. Understood? That is as simple as that. That's a minority concept. So nowhere defined in the constitution. Fine. Again, if in case a little go in depth, they go. Just for your clarity, both center plus states can identify minorities, both type of minorities. Both center and states can identify their own minorities. Both center and states can identify their own minorities. Fine? Yeah, because that question is already there. Of course, 20-point program, all those ones, it's very easy to understand. We'll discuss that. Then 30. What is it? Educational rights of minorities. 30, clause 1, clause 2, all of those things are not necessary. First point. Only one, again, only for whom? This is only for minorities. 29 is for both minority and majority. That is only for minorities. Understood? So educational rights. In simple terms, what do you mean by educational rights? Right to establish, manage, right to establish and manage their own educational institutions. Right to establish and manage their own educational institutions. Right to establish and manage their own educational institutions. Right? Rest all obviously you can easily understand. Okay, if in case you want. 44th Amendment 1978. mandatory compensation if properties of minority educational institution is acquired by government. Forty-fourth Amendment, 1978. Mandatory compensation if the properties of minority educational institutions is acquired by the government. Right? Again, just to mention core points, I will clarify it. Which one? The landmark. What? Karnataka case, famously what you call it as? Manipal case. TMA Pi Foundation case. Simple. Article 30. What Supreme Court told? Article 30 is not absolute. In other words, who can restrict it? Government can regulate it. Article 30 is not absolute. Government can regulate it. Sure. Another one. There are so many, but we will not write. We are not writing this for the case concepts, because that all is part of which one? That cases, remembering, writing, everything is means. In prelims, nobody will ask you which cases, all those things. They will test you largely the concept, except maybe some landmark cases. St. Stephen's College case. Yeah, what is it related to? Maximum, that is up to 50% seats in MEI, minority educational institution, can be reserved for their own community. Can be reserved for their own community. Another very simple, keep it in mind. In MEI, what is not allowed? No reservations. No RTE Act 2008. If you recall, in RTE Act, Pratima, what do you call this? Not Pramati Educational Foundation case. Minority educational institutions, no reservations, no RTE Act, nothing will apply. Short means what? Students will also not get reservation. Who will also not? Even in, let's say for example, some professors are there. If you take any university, Bangalore University, Mysore University, all of them, even in the assistant professor position, what is there? Reservation, same OBC, SC, ST, women, Hyderabad, all of these things are there. In minority, what is it? No reservation whatsoever. No SC, no ST, no women, no OBC, nothing. So whatever they want, accordingly they can, what do you call this, choose. So, and then few others are also there, not necessary. Recently, which case? Aligarh Muslim University case. Again, what Supreme Court told? It is a minority institution. Their own old case was there. If you have heard, called as what? Aziz Basha case. Aziz Basha judgment, not repealed, overruled. AMU, Aligarh Muslim University case. Supreme Court told it is an MEI. See, these are all kind of current affairs, kind of basics, all interlinked. Aligarh Muslim University case, it is a minority educational institution. Fine. That is the core points that you have to keep it in mind. Then directly Article 32. Assured. Right to constitutional remedy. Assured, in simple terms, what is it? Enforcement of rights, fundamental rights. What is it? According to Ambedkar, you tell. Yeah, very famous statements. Article 32 is for whom? Supreme Court. Understood? Same power, very famous, obviously whom? 226 High Courts. If a fundamental right is violated, one can go to where? Either Supreme Court or High Court. In other words, Article 32 is original but not exclusive. Why is it called as original? Because you can directly go to Supreme Court. Why is it not exclusive? Because you can also go to High Courts. Exclusive, if you want to say original and exclusive, what it has to be then? Only Supreme Court then. Understood? That's the basic ones. And obviously, you know, concept of writs, which country? Okay, we'll come to that later. Very simple ones. Supreme Court can issue writs throughout the territory of India. High Court? Of course, exception is there, that's a different issue. Fine, that's your simple differences between 32 and 226. And now comes here which concept? Obviously, types of writs. Obviously, you know, concept is borrowed from where? UK. First type is what? So obviously you get lots of questions from here. To have the body of when is it used? In case of any illegal detention they use it. Understood? Against whom? used against public authority or private individual, means you can use it against government or against us, private individuals also. You can't use it if detention is legal. So who has to apply the writ petition here? Affected members. Rarely individual with public interest. Means rarely anybody can apply. Rarely individual with public interest. Fine, okay, the most important one, that is, then comes what? So when is it used? Used if public authorities have failed to perform their duty properly. If public authorities have failed to perform duty properly. That is your mandamus. In other words, when you are clearly using if public authority, means it's not available for whom? Not used against. Not used against private individuals, corporations, president, governor, chief justice of high court, etc. Actually, it can be used against PSUs, but there is a confusing question that we'll go through it. When you say public authorities, does it include PSUs? Does it include PSUs when they perform any kind of function? That was a confusion. We'll go through that question. We'll look at it. Then you'll get a better idea. Fine, whatever. That is the point. When is it used? Only if public authorities has failed to perform their duty properly. Not used against private individuals, corporations, president, governor, chief justice of high court. Fine. Then comes your which one? Prohibition. In simple terms, what is it? We forbid. It is issued against whom? Issued against courts, tribunals. Means, in other words, Okay, fine. In other lower courts, in other words, not against. Not against legislature, executive. I should obviously what? Look at the word prohibition. What does it mean? To prevent. Prohibition. To prevent breach of jurisdiction. To prevent breach of jurisdiction. So you can't breach the jurisdiction. That's why what is it? By definition, what is it? Preventive. Stop you from doing something. Yeah, extension of this is which one? Certiorari. To be informed or certified. Preventive plus what? Curative. Same. Issued against. Issued against lower courts and tribunals. Issued against lower courts, tribunals. It's a plus executive, not legislature. Understood? So why is it same? Why is it preventive? Transfer case. Why is it curative? Quash orders. Whatever orders that you have given, they may quash it. That's why it's curative. Quash means what? Cancel or transfer it before itself. That's why it's preventive. So it is available against executive also, but not against legislature. Fine? Then the last most important one, quo warranto. On what legal basis? Why is it used? To check if, not to check actually, you can say, used if an individual, used if an individual has occupied, if an individual has occupied substantive public position illegally without eligibility. If an individual has occupied substantive public position illegally, sure, that is without eligibility. Sir, what is substantive public position? Again, not defined, but lastly you can take it as what? President, PM, CAG, UPSC, what do you call this, Chief Election Commissioners, whatever, etc., governors, CMs, so Cabinet Secretary, Chief Secretary, CBI heads, very important public positions. Of course, it's not defined, courts will clarify it time by, case by case. So who can file quo warranto? Oh, this one. Filed by anybody. So anybody can go and file this petition in the courts. Filed by anybody. What about others? Other four writs, normally who? Affected members. Quo warranto, anybody. Other four writs, only affected members. filed by anybody, other 4 writs, anybody, I mean only affected members. Only affected members. Fine. Yeah, that is your largely the writ concept. If in case we ask you very simple ones, writs are available to whom? Obviously answer is what? In general. When you say in general, remember both citizens plus foreigners. Because by definition, fundamental rights are available for whom? Both. Of course, except few for foreigners. So that's why if you are giving fundamental rights to someone, obviously what you should also give them? You should also give them the opportunity to enforce it if it's violated. So that's as simple as that. Then other things actually doesn't matter much. So I'll just sum up very quickly 1 or 2 lines. 33 is what? Compromising. These no time, even in prelims and mains, nowhere it matters. Compromising fundamental rights of whom? Armed forces. When you say armed forces, obviously who all? Army, Navy, Air Force, everybody includes. Compromising the fundamental rights of armed forces. Simple terms is that. Of course, for what purpose? To maintain discipline and confidentiality of information. Not only officers, anybody working for armed forces, their rights are compromised. Which one? Freedom of speech, express, all those ones? Not necessary, not even matters much, don't worry. 34. What is it? Compromising fundamental rights during martial law. Compromising fundamental rights during martial law. Compromising fundamental rights during martial law. Fundamental rights during martial law. Fine. Again, what is it? We don't know, no clarity. Not defined. Unsure. When do they use it? Army takes over. Completely army takes over. Army control. Army takes over everything. Fine. Then, which conditions? Same obviously. Law and order out of control. What happens to fundamental rights? Of course, just now we are told. Fundamental rights compromised. Fine, that's it. Other things don't need to worry. We have never imposed a martial law in India after, once the constitution has come into force. Fine. Then 35. 35 is what then? Parliament can pass acts to implement. Parliament can pass acts to implement certain fundamental rights. Understood? Obviously, we all know so many things. Example, Article 16, Clause 3. What is it? Residence as a criteria. The residence can be made as a criteria for certain jobs. Understood? Same way, Article 17, Article 23, Article 24. Understood? Article 32, 33, 34. For all of those things, only who can make laws? Only Parliament. In other words, who not? Not state legislature. Why? Uniformity across country. No need to worry. UPSC doesn't ask such questions. Uniformity across country. What if it's a state subject? Doesn't matter. Even if it's state subject. Even if it's state subject. Understood? What is it? It is fine. In other words, you can't question it in the courts that it is violating federalism. You cannot, not allowed. It's an exception. Even if it's a state subject, it is still fine. Only who will pass act? Parliament will pass act. to implement certain fundamental rights. Fine? Yeah, so we have come to the almost the end. Broader aspect, right to, because last year there was a case, if you recall, Maharashtra Property Owners Association related to 31C in a way, but overall right to property. Just to mention, 19 clause 1 subclause F, article 31, both are what? Right to property, both are deleted by, recall which one? 44th Amendment 1978. Answered. The same amendment added 300 capital A. That's why what is it? Right to property, constitutional rights plus legal right plus you can say statutory right, all of them. Answered. And if you recall 300A, the word mentioned is what? They use the term person. That's why that means it's for whom? Both citizens plus foreigners. So that's your one question, we'll go through it. But it says no person shall be deprived of his right to property except by the authority of law. Because the term mentioned is person, it's available for both Indians, that is citizens plus foreigners. Fine? Yeah, that is your simple right to property. In other words, indirectly you tell, what if right to property is violated today? If right to property is violated, because it's a constitutional, in other words, it's not a fundamental right, what is it allowed? In simple terms, go to where? Go to high courts. In other words, not to. You can't go directly to Supreme Court. And who can amend it directly? Parliament can amend right to property directly. In other words, what's not needed? Constitutional amendment not needed. Parliament can amend right to property directly. Constitutional amendment is not needed. Constitutional amendment is not needed. Constitutional amendment is not needed. Fine. That is basics about your right to property. First is 31A capital A. First constitutional amendment 1951. Answered. What does it tell? Whatever, all those details are not necessary. Core point. On which are those subjects? That's obviously not so important for prelims. If you recall, acquisition of estates and related rights, mergers and acquisition of the corporations, taking over the management of companies or properties by the state, what do you call this, modification or termination of mining leases, modification or termination of the rights of landholder, shareholders or managers, whatever, all of those ones, not necessary. Overall, even if it's an act passed by parliament or state legislature, so it cannot be questioned in courts even if it violates Article 14 or 19. Exception. That's why 31A again is not giving you a right. What is it doing? It is making exception to your right. Which right? Obviously 31 means to your right to property. It is making an exception. So even then there are few ones. If you recall, mandatory compensation is allowed if in case the land is what? Within the statutory ceiling limit, and then personal those are all not necessary for prelims. Not a single question. Maximum what they'll ask, 31A added by, that's it. Even this they will not go. Only for your information sake I mentioned this. 31B, again which one? This we have already done in detail. First Amendment 1951. It's famously related to which one? Famously related to 9th schedule. Any act passed by Parliament or state legislature cannot be questioned in any court even if it violates what? Any fundamental rights. That's why look at the word any acts, any court, any fundamental right, any subject actually. That's why simple terms what do we call it as? Article 31 capital B greater than Article 31 capital A. 31 capital B greater than 31 capital A. 31 capital B greater than 31 capital A. Fine, and then you have IR Colo case that I have already told you. But what, even if add, who can add it also we have told who can add it. Only it can be a state act. State can pass their own acts, agreed. But if you want protection, it has to be added to 9th schedule. And who can add it? Only Parliament. 368 special majority. So even if you add it now, what is it? It can still be questioned by courts. It can still be declared unconstitutional, but it should violate not fundamental right just, it should violate basic structure. That's why if you recall, dual test we have already mentioned, IR Colo case, landmark. In simple terms, they may ask IR Colo case is famously associated with which article or which one? 31 capital B. Fine. Then last, just a few months back, Supreme Court again gave a clarity on 31 capital C. Which amendment this is? 25th Amendment 1971. Any act or policy cannot be questioned in courts. Any act or policy cannot be questioned in courts if it implements or if it tries to implement which one? Recall? 39 clause B, 39 clause C, even if it violates Article 14 or 19. Any act or policy cannot be questioned in the courts if it tries to implement 39 clause B or clause C, even if it violates Article 14 or 19. Ensured, and Supreme Court upheld this one in which one? Keshwananda Bharati case. Recently, what is the issue? Recently, the issue was, if you recall, what does 31 clause B say? If you recall, properties can be used, or not properties, you can say, any kind of resources can be used for common benefit of all. Ensured. And Supreme Court earlier in whatever during the Nehruvian so-called Nehruvian Indira Gandhi kind of socialistic era, what they are told, private property, any private property can be used for common benefit of all. In other words, Supreme Court had told, whatever private properties, whatever you have, your land, your agricultural land, your property, whatever it is, Supreme Court told that what? Government, if they wanted, they can use it for whose benefit? Common man's benefit. Because that was a different era. Now what is it? Now it's a different era. Now what is it? Right to property, they take it very seriously because you are in a neoliberal capitalistic era. That was originally told in, if you recall, even one of the Karnataka case was also there. Ranganath Reddy case, Sanjeev Coke manufacturing case, all of them were there. Kind of landmark cases related to right to property. Recently this year in Maharashtra property association case, what Supreme Court told? Private property cannot be used for whose benefit? Common man's, or what do you call this? So-called common benefit. No, because private property by definition means what? It's for individual. How can government just acquire it for whose benefit? Overall benefit, not allowed. Assured. Yeah, just clarify that if you want. The recent one, Maharashtra Property Association Owners Case. Property Owners Association case, sorry. Again, not a very landmark case because all these doesn't matter too much now. Maharashtra Property Owners Association case. What Supreme Court said? Private property cannot be acquired by government private property cannot be acquired by the government for common benefit of all. Don't take it as common resource also, or cannot be considered as common resource, whatever. For common benefit of all, or it can't, don't consider it as a common resource. That's why if you recall it, there is a domain, the concept you apply if you have heard. What is it? If you have followed newspaper, you would have come across a doctrine of eminent domain, they tell. Kind of current affairs also, but famous one. Doctrine of which one? Eminent domain. Normally I don't tell all these things in your normal basic classes. Even now it doesn't matter much because the case was there, that's why. So what do you mean by doctrine of eminent domain? That doctrine of eminent domain means in simple terms that government has all the power to acquire individuals' private property also. That is doctrine of eminent domain. That's why if you have heard in 1894 Land Acquisition Act, British era, there was that clause. So in simple terms, eminent domain means what? So please write that government has all the power to acquire any private property for public benefit. Government has all the power to acquire any private property for public benefit. That is doctrine of eminent domain. But what is the point? However, it should be for public purpose or public interest. However, it should be for public interest. That is one first key point. Public interest it should be. Two is what? Fair compensation. Means I think you can understand. Means what? You can, if you want to acquire it, but what do you do? Give them fair compensation. Fair compensation. 3. Due process of law. Means what? Before acquiring, give a notification to them, let them respond. Due process of law should be followed. And what is it? Overall process. Overall process should be what? Non-discriminatory. Non-discriminatory, non-arbitrary. It should be for public benefit, public interest, and should then follow the procedure properly, pay the compensation properly. Then if you want to acquire it for what? Public interest, even if what? Remember, eminent domain means the power of the government to acquire someone's private property, even if that person doesn't agree. Unsure. Yeah, that's why even if they don't agree, when can you acquire? It should be for what? Public interest. Unsure. Give them compensation. Follow at least the process properly. Try to ask their opinion. Are they okay? Everything. Even if they don't agree at the end, sometimes you can't help. What you have to do? You have to take it. So, doctrine of eminent domain. Under 1894 British Act, it was very, very powerful. Now it's not so powerful. It has all compromised a lot. Overall, those are the points related to your fundamental rights. Obviously, a very, very detailed chapter. Just try to. Okay. One second. Not uploaded it. No, 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 no. Nothing is compulsory, ultimately left to the parliament. Means even if state legislature passes an act, even if state legislature requests that please add our act to 9th schedule, there is no compulsory. Parliament final decision. Correct, yes. That's what we told. That is what is mentioned in the article. But Supreme Court in IR Colo case has already clarified it. If you recall, in the when did you write schedules, today or yesterday? Yesterday, if you recall clearly, we told that IR Colo case, Supreme Court has clearly told that whatever you wrote here now is what is there in the Constitution. What we have written in IR Colo case, who gave clarity? Supreme Court has given clarity already. Even if you add an act to 9 schedule, judicial review will apply. It can still be declared unconstitutional, but it should violate basic structure. Yesterday, we have written it something called as dual test also. Yes, it will apply. Yeah, so try to go through few questions. If in case anybody has options or anything, you can leave. But because or else again we have to come back tomorrow again, continue with the same things. So just a matter of few minutes, because yeah, so this one you go through it. Now it's done. Morning, whatever first question we did it. First statement is what? Of course, correct. Which article? That is what is here. Which article? A right to establish and administer exclusive educational institutions. Just now you wrote. You are talking about national minority. Article 30. 29 is cultural rights. 26 is what? 26 is? Esto class? 5:45 ga. Okay. 6 o'clock galwa. Okay, fine. So, the first statement is obviously referring to Article 30. That's right. Second is what? President automatically nominates a representative of the community to Lok Sabha. There is nothing like that. Even if you have still not done parliament also, you can assume obviously that kind of automatically nominated concept itself is not there. Nomination is only there for whom? Anglo-Indians. That anyhow we'll discuss it, but you will be knowing that. So just take out 2. Derive benefits from Prime Minister's 15-point program. Yes, because and just to keep it in mind, it's a kind of a current affair angle, because obviously look at the year 2011, means when UPA was there, obviously because Congress was in power, they had brought something called as Prime Minister's 15-point program also. During Indira Gandhi time, there was something called as 20-point program also. Actually answer is yes. Even if you take the basic concept is what? Always remember, in general, what is the point? Government cannot do anything, or government has to do what? Or has to take extra measures for whose benefit always? Minority benefit also. BJP is different, you leave that. In general, I am telling, any government has to take extraordinary measures for the benefit of minorities. That is how inclusive secular constitutions work. Now concepts are getting redefined, that's a different issue. But in general, the point is theoretically, answer is yes. Now sure, that means answer is what then? 1 and 3. Okay, NGT will discuss, I will tell you when we discuss your very simple ones, look at it. Very simple. We discuss so much of in detail, but they will ask you very simple questions. We have done it so that if in case they make it a little technical, little detailed also, you should be in a position to handle it. Simple, they are asking what is right against exploitation consists of how many articles? Obviously 23, 24. What is 23? Human trafficking, forced labor. What is 24? Child labor. That means look at it. Yeah, that's it. That I already clarified it. This we did it. This is more simple. I don't even have to discuss. Look at it. Right to privacy. Obviously, Chan. 21. Obviously, which case? Case, Padaswamy case, and I told you within that there are so many: right to choice, right to what do you call as this, right to be forgotten, right against. Not right against reproductive rights of women, so many are there, right to publicity now, or right to personality rights, all of them is part of that. It's a very detailed article. Rule of law, we did it. Yeah, again this one, right to marry, Article 21, broadly right to privacy, dignified life. If you want case, what is it, Hadia case, but again the case nobody will ask you, just to keep it in mind. In normal book concepts we actually keep doing it. Okay, this is Universal Declaration of Human Rights. Okay, then duties. Where is the writs question? Sovereignty, fundamental duties. Another very simple, which of the following categories incorporate protection against untouchability? I think that's very simple, I don't even have to tell. Then yeah, go through this. It was a little confusing one. Yeah, so yeah, good. Whoever said that answer, but tell me the logic. So first, I mean the reason first. Mandamus will not lie against a private organization unless it is entrusted with public duty. But if you recall, we had clearly mentioned that mandamus will not work against private individuals or corporation. But what they have added, unless it is entrusted with public duty, and if even in Article 12 also we told a private organization or a private what do you call this can be considered as part of state if it is what? If it is working with the state on a public project. Exactly, that's the word. In simple terms, you can be a private company, but if you are working with the government on a public duty, you are also what? You are also state, you are also public authority. Hence, mandamus can be issued even against you. So 2. Will not lie against a company even though it may be a government company. No, because government means what? Public authority can be issued. So that means 2 is what? Wrong. So 2 is wrong. Actually, I don't know the official answer. Official answer that it became a very controversial one. I still forget, keep forgetting the official answer for this. I am telling overall answer, second statement is wrong. It will lie against government company because by definition government company means what? PSU. And so it will work. Third is what? Just now I told. Quo warranto, who can apply? Anybody can apply, but other 4 writs only affected members. So answer is actually 1 and 3. But for your clarity, please go and check the official key. Someone, right to property in India, what is it? Just now I told. Available to whom? Any person. Understood? Because the word mentioned is what? Person itself. Or in other words, even if they mention citizen also, you can take that. Yeah, unguided, undiscreet. That why I told you morning itself. Right to privacy again, another one. Yeah, due process of law, I just clearly told you which one. Due process of law, see, yeah, 2 types of asking the question. Let's take out the term in essence. You delete the term in essence. And what is the question is, what does due process of law mean? Fair application of law. In simple terms, remember, simple definition of due process of law is fair application of law. If you add in essence, what does it mean? The most appropriate definition. That is what? Principles of natural justice. Unsure. That was a little confusing. Supreme UPSC has clarified that. Actually, as far as I recall, this question they have deleted. But even if you take otherwise, so try to tell me what can be the answer for this. Just now you wrote all of those ones. It has to be First Amendment because First Amendment added what? 31 capital A. First Amendment added 31 capital B. So large, even if you take for that matter, so many other exceptions to 19 clause 1 subclause A, freedom of speech and expression also was added by First Amendment. So First Amendment made lots of compromises on fundamental rights. And so that's why it is First Amendment. Few people had argued 42nd Amendment also made. Yes, but larger exceptions were made by which one? First Amendment. Actual answer should have been first. Maybe because there were different interpretations. As far as I recall, UPSC cancelled this question. Just go and clarify, but that's why if you look at it, the First Amendment will be the answer. Right to privacy again, 24. And so 2024 they have again asked it. How many questions? I think this is the 3rd time you are going to right to privacy. Look at it. Constitutionalism, parliamentary system, federalism, what do you call this? State is they have not repeated. Like that, so many questions are there. Time and again they repeat. Another repeat is this. Fine. Yeah, prohibition. I think this is 25 or 24. Writ of prohibition issued by Supreme Court or High Court. 2. Prohibition. Understood? Issued by whom? Lower courts and tribunals. Keep that in mind and go through it. Issued by Supreme Court or High Court. 2. Government officer prohibiting him from taking an action. Parliament or assembly to pass a resolution. Lower court prohibiting continuation of proceedings. Which one? Lower court. It is issued only to lower courts and tribunals. I think few other questions were there, maybe on fundamental rights. I'll just go through it tomorrow. Yeah, maybe I'll upload this in your which one? Whatever I'll forward it Telegram channel. Whatever they'll do that thing. Fine. Tomorrow we'll continue with your DPSP. Timings will remain the same. Why to unnecessarily confuse? Stick to the same timings. 9.